Thank you for joining us today at Immigration Relief and Introduction. I'm Ala Policastro, CLE Advisor for the Beverly Hills Bar Association, and today I am delighted to introduce our speaker, Habiba Simjee. Habiba is the Director of Pro Bono at Counsel for Justice, where she leads efforts to expand access to justice for those underserved communities seeking to assert their legal rights. She has dedicated her career to advancing immigrant rights and has supported legal aid leaders across California through her previous work at One Justice and the University of California system. Habiba also teaches immigration law as an adjunct professor at the University of La Verne College of Law and Public Service. We can't wait to hear what you have to share with us today, Habiba.
Thank you so much for that introduction. Right, let's go ahead and get started, everyone. As mentioned, I'm with Counsel for Justice, and today I'm going to do a very broad overview of immigration relief as an
Excuse me,
introduction.
Habiba? It
Yes,
looks like we're sharing the wrong monitor. We
got
can.
it. Okay, thank you. Apologies for that. So while I share the correct monitor, today I wanted to talk about the forms of relief that we screen for in our immigration legal services clinic, the Immigration Legal Assistance Project, also known as ILAP at Counsel for Justice. So to start, we're going to talk about just some basic fundamentals so that we're all on the same page about terminology and what we're discussing with the clients that come in. That's going to be the bulk of our discussion today, with a focus on what we see most in the context of our pro bono immigration legal services. And then we'll close with a little bit of discussion on inadmissibility. Spoiler alert, we will have so much to talk about with pathways to legal status that we're not going to have a lot of time to talk about the very important topic of inadmissibility. However, we have materials on inadmissibility and also the pathways to legal status for more details. And of course, I'm always happy to answer questions. So I'll be putting up my email, the Volunteer Counsel for Justice email on this slide, which routes to me, and then again at the end of the presentation. So Counsel for Justice, just as a quick note, we actually have a few issue areas that we work on. By and large, our largest project is the Immigration Legal Services project, and that is, we've been doing that for 50 years. We're actually celebrating our 50th anniversary this year. We also have our Domestic Violence Restraining Order Clinic located at Stanley Mosque. We also serve veterans, and we have a new housing unlawful detainer answer clinic. So let's go ahead and get started with the fundamentals. So first off, we want to make sure that everyone is kind of familiar with who are the key players in the field when we're talking about the agencies that we're dealing with our immigrant clients. So some of you may have heard about the Immigration and Naturalization Services, INS. So INS used to be the department or the agency that was kind of in charge of all the immigration applications and services. And now, since over the last 20 plus years now, since September 11th, we now have the U.S. Department of Homeland Security. And there are 3 branches under the U.S. Department of Homeland Security that we're primarily concerned with. U.S. Citizenship and Immigration Services, which adjudicates applications for immigration that we're going to talk about. U.S. Customs and Border Protection, or CBP as we hear about. That's who we see at the airports and land border entries. So ports of entry, and then U.S. Immigration Customs Enforcement, ICE. That's been in the news quite a bit. So I imagine everyone's familiar with these agencies now. And then we have a few other departments that are tangentially involved in the immigration process. So under the Department of Justice, we have the immigration court system. So the Executive Office of Immigration Review, or EOIR, as it's called, and the Board of Immigration Appeals that actually sits under the Department of Justice. Then we have the Department of State, aka DOS, and that deals with the visa issuances and consulates. So if anybody is getting their process completed abroad, like getting their visa, whether it's an immigrant visa or non-immigrant visa, for example, a tourist visa on the non-immigrant side, or family petition completed abroad, then they would go to their consulate in their home country, which is run by the Department of State. Department of Labor takes care of employment based petitions, the underlying labor certifications, excuse me. And then the Department of Health and Human Services is involved in refugee resettlement and unaccompanied children programs. Okay, some more basics. So I like to parse out who we're talking about when we talk about non-citizens, and that's includes individuals who are lawful permanent residents, aka green card holders. We have non-immigrants, so as I just mentioned, individuals who hold temporary visas, so like tourist visas or business visas, or folks have heard of H-1B or agricultural worker visas, for example. So non-immigrant, that term is odd, but it really just signifies people who don't have the intention of living in the US permanently. That's why they're on temporary non-immigrant visas versus immigrant visas, like for family petitions or employment-based petitions, where people have the intention of obtaining their permanent residence and eventually their citizenship. And then we have undocumented immigrants who have no form of legal status in the United States, except for, and I'll go to the next slide, individuals who are considered undocumented, but have maybe like a temporary just form of protection. So at the bottom here, and I want to acknowledge all the contributors to these slides over the years that I have been using. So a lovely graduate student here created this at UCLA. But the temporary protected status and deferred action for childhood arrivals that have the red X next to them, we consider them under the undocumented bubble, for example, because what we're referring to here with TPS and DACA are not long-term forms of immigration relief. They do not lead to a pathway to a green card or citizenship in and of themselves, and neither are they non-immigrant visas. And so we see certain categories kind of float within the undocumented immigrant bubble. And then, so this chart really helps us understand that there's kind of a spectrum of options as we move towards gaining US citizenship. So people who are on the pathway to citizenship can be obtaining it potentially through family or employment-based petitions, or some of the humanitarian forms of relief that I'll be talking about in just a few moments. And through that, they can obtain a lawful permanent residency or LPR status or a green card. All of those are used interchangeably. And then after a certain amount of time in LPR status, can apply for naturalization. And the big asterisk there is that folks always need to be screened for anything that might cause them issues at the point that they're applying for things like inadmissibility for a green card, or issues that might bar them from naturalization. So big asterisks there that we won't actually have a lot of time to get to today. But we're going to go ahead and get into that pathways discussion. It's going to be the majority of our time together here right now. So the pathways to permanent residence include, as I mentioned, family-based. We're going to talk about the two sort of subgroups under family-based. And then employment-based. So employment-based includes some non-immigrant or temporary categories that can have the opportunity to maybe transition into a pathway to green card. But really the main folks who are on the pathway to permanent residence or employment-based options are in the employment-based preference categories. And I'm not going to actually discuss employment-based opportunities for permanent residence today. I'm going to leave that to our amazing colleagues who are in the private bar. This is, not an area that a lot of legal aid or nonprofit legal services works on. And so as such, I'm going to focus on kind of what we see with respect to individuals who may not have those kind of opportunities in the employment-based category. I'm also not really going to talk about diversity visas because it's a lottery system. And so it's really just a quota and kind of folks applying to this lottery for countries that have fewer individuals who immigrate to the US from. I will focus more on some of the humanitarian forms of relief, which is tends to be more of the bread and butter of the legal aid sector. And when we do consultations in the pro bono context. So we're going to talk about asylum, the Violence Against Women's Act or VAWA, the T non-immigrant visa, U non-immigrant visa, and special immigrant juvenile status or SIJS. So what I want to walk everyone through is the pathways to legal status as we discuss it with in our sort of community facing methods. So with intake, how we ask the questions. So that can help us get to the pathways to legal status. So with family-based petitions, the first question that we generally start with is, do you have any immediate family members with legal status? Are you married or have you ever been married? If so, what is your spouse's legal status? Do you have any children? If so, what are their ages and what is their legal status? Do you have any US citizen siblings? Were any of your parents, step parents, or grandparents US citizens? Has anyone ever submitted an immigration application to help you gain legal status in the US? If so, when? And have any of your immediate family members ever served in the US military or armed forces? So this is kind of a long list of questions that allow us to get to what are some of the options that an individual might have through family. And so as you can see, there's a lot of questions here that we have to parse through with folks. And this is actually not even, the full list of questions. Tried to make it a little more slide friendly by making some of them a little more general or combining questions. So some intakes you'll see might even be much more specific with even longer questions. But really, we're trying to get to a couple different things with family-based petitions. First of all, are there immediate family members who might be able to petition the individual who is seeking legal status, and how they could go about that. So there are different options. For example, the last question related to U.S. military or armed forces, family members being in the U.S. military or armed forces, has to do with a form of relief called parole in place, military parole in place. So just to give you context as to why we ask that, individuals who have an immediate family member who served in the U.S. military armed forces may be able to benefit by not only having that family member submit a petition for them, but because we have so many individuals who entered the country without inspection and thus have challenges actually following through on the pathway to obtaining their green card, what happens when we have a family member who petitions for them who's been in who have been in the military armed forces, they can petition the family member through parole in place, meaning they don't even need to leave the country and trigger certain inadmissibility issues, which we'll touch on at the end, that would otherwise cause them significant barriers to being able to adjust their status. So that's just one example as to why we ask these detailed questions. So with these questions, what we're getting at is really the core of family-based petitions, which are divided up into immediate relatives and preference categories. So individuals who fall under the immediate relative category as defined under immigration law are beneficiaries of a certain U.S. citizen or U.S. citizens, and the beneficiaries are somewhat specific here. So as we can see, the unmarried under 21 children of U.S. citizen. So note there that here immigration law defines child as under 21, not under 18. That's super important for us in our screenings, because age 21 is a major cutoff in family-based petitions, and in particular, of course, but any situation where family members are trying to include their children in their application. So they must be under 21 to be considered a child for the purposes of immigration law, and unmarried. So again, children of US citizens, uh, parents of US citizens where the US citizen is over 21. So the adult son or daughter, which is how we distinguish between child and an adult child. In immigration laws, we say adult son or daughter versus a child, which is under 21. So an adult son or daughter who's a US citizen can petition for their parent. And then the spouses of US citizens are also considered immediate relatives. So those categories seem to be a little more straightforward. Preference categories is where we see things getting more complicated. So here, under preference categories, we have a matrix of options, and the category that an individual is in is very important, as we'll show on the next slide, because it has to do with how long they have a wait time in the visa bulletin. So that's where we go back to the Department of State and sort of the calculations regarding wait times for immigrants. So immediate relatives, the most important takeaway there is that they have no formal wait time. If it takes time to gain legal status through, say, a petition as a spouse of a US citizen, that's because of processing time and sort of reviewing and adjudicating the application. But other than that, there is no waiting in line to get an immigrant visa as an immediate relative. Preference categories, the second matrix is much more complicated because we have to look at the wait times, which I'll show you on the next slide in just a moment. So we have 5 categories, really four, but one of them split into two, where we see that folks who fell outside of the scope of immediate relatives may have other opportunities. So, for example, when we talked about the adults, sons and daughters of US citizens, even though they're no longer immediate relatives, they might they can still be petitioned by a U.S. citizen parent, but they'd either fall under F1 or F3, depending on whether they're married or unmarried, as you can see. And so they will have wait times, unlike their younger siblings who are under 21, for example. We also have options through lawful permanent resident petitioners. So if someone has a green card, they can petition for their spouse and children, again, children unmarried and under 21. And they can actually petition for their adult sons and daughters who are over 21, but no, only unmarried sons and daughters over 21, not married sons and daughters. So, in addition to the many benefits there are to naturalizing in the US and encouraging our community members who are able to naturalize and become US citizens, there's benefits that are wider ranging that have implications for the family members as well, an ability to petition more family members. Lastly, we have the F4 category for brothers and sisters of US citizens, which is why we asked in the last slide in the intake questions about whether they have siblings who are US citizens. So the visa bulletin is available at on the State Department website. Here's the link on the slide. I often just Google it for the most recent version, so you don't have to write down this whole hyperlink or even click on the slide later. As long as you go to travel.state.gov. And as you can see, so I took a screenshot of the most recent visa bulletin. I was putting together these slides. And so this is the current visa bulletin for the month of July of 2025. And the way that we read it is it lines up in terms of the categories, so the rows F1, F2A, F2B, F3, and F4 with what we talked about in the previous slides with respect to the preference categories. So we see what the categories signify. And then what we see is 5 different lines for waiting. I've heard this described in really interesting and some funny ways, like, you know, your ticket at the deli line, and waiting for your ticket to get called. But then there's 5 lines at the deli, depending on what country you're from. So I've always loved that explanation. And basically, the reason we see these sort of 4 columns for China, India, Mexico, and the Philippines is because those are major sending countries, and there are more individuals from those countries who are applying in these categories, and there are from all the other countries in the world. And because of quotas and some complex calculations that we certainly won't have time to get to today, we see that the timeline can look different for folks from those categories. Although, if you look closely at the China column, for example, right now, interestingly, it actually tracks with the rest of the countries in the world. So China is sort of a superfluous column right now because it's actually the same as for everyone else except India, Mexico, Philippines. And I know that this is not an unmute webinar, so I won't be asking for shout out answers, but I generally like to pause here and just test our reading of the visa bulletin, so that we know what to tell folks when they ask us. You know, so it's someone who is the brother or sister of a US citizen, and this individual, let's just say a brother of a US citizen, is from the Philippines, and he says that his U.S. citizen brother petitioned for him in at the beginning of last year, so January of 2024. How long will it take for that petition, according to today's visa bulletin? How long will it take for that petition to get adjudicated? So, how we read this the dates on here is that it's done with sort of the international style of dates, so month, or sorry, excuse me, I still did it the American way, day, month, year. So we're going to first go to the category that was mentioned. So they said brother or sister of a US citizen. So we're going to F4, so that last row, and then I mentioned that they're from the Philippines. And so we're going to go to the last column, so that very bottom right corner of this table, and we see that it says 1st of January 06, so 2006. So that references the date of the petitions that they're currently that are currently up for a visa. So again, that ticket at the deli line being called is the analogy that I appreciate. And so if they're now calling petitions that were filed as of the 1st of January 2006, and this person tells you that their brother filed a petition for them in January 2024, that means we're looking at an approximate 18-year wait. And that's at a minimum because the visa bulletin can change, and often the times get longer, not shorter. So again, don't want to, harp on the calculations and the complexities of the quotas, but it does help us understand why there are so many folks who are, waiting to be able to adjust their status or gain legal status in the US, is there's a lot of family members who are either waiting for their petitions, or they may qualify even as immediate relatives, like lots of parents of US citizens, but they have certain inadmissibility issues, which we'll get to at the end. So I want to transition to talking about the humanitarian forms of relief. And again, I'll start with some of the questions that we ask in the intake process to help us understand a client's story and what may impact their immigration options. So I'm going to start with the Violence Against Women's Act, or VAWA, which is actually not gender specific. I know we see the term women's in there. However, VAWA is gender neutral, and individuals who don't identify as women can apply also. The question that we start with is, have you ever been threatened or harmed by a US citizen, spouse, parent, step parent, or adult son or daughter? And also, and I apologize that we don't have the second part of the question here, it's US citizen or permanent resident. And again, the reason I'm starting with this humanitarian form of relief is it's the most closely related to the family-based petitions. So I'm going to actually go back again. The reason that we have these VAWA protections is to untether an immigrant from their abuser, who is in charge of petitioning them for their immigration status. So again, when we revisit that question, the idea is that for a non-citizen spouse or child of a US citizen or lawful permanent resident, they can become a VAWA self-petitioner, so they don't have to depend on the US citizen or permanent resident who's the abuser to petition for them. And to qualify under INA 204A, the Immigration and Nationality Act, apologies, the individual must have suffered abuse by the US citizen or permanent resident, spouse, parent, or step parent, Or is the child, whether the child was directly abused, of a parent who was abused by a US citizen or permanent resident spouse? Also, there, as we see in the immediate relative categories, we see that parents of U.S. citizens who are over 21 are also eligible as immediate relatives to be petitioned, and so there is also a carve out for the abused non-citizen parent of a U.S. citizen. So basically, in a situation where there's elder abuse. So the VAWA was has been intended to allow individuals who would otherwise qualify um, to be petitioned by, again, a spouse, parent, or step parent, or in the case of a adult son or daughter who's a U.S. citizen and the abuser, um, to allow immigrants to not have to be petitioned by them and submit their own forms. And of course, for all of these categories that we're going to talk about with respect to humanitarian relief, there we could spend at least an hour on each of these categories, discussing the details, discussing, evidentiary needs, and kind of what else do people need to know once you've flagged that someone, for example, may meet the definition under VAWA, like what do we need to gather from them? What are the next steps and additional information? I'm going to put up some resources at the end so that if you'd like to do a deeper dive into any of these topic areas, there's some excellent short training videos that are available that do deeper dives and walk us through each of these petitions. So next, I'm going to go through asylum, which a lot of folks have probably heard about. And asylum is tracks with the international definition of a refugee under the Refugee Convention. And so the Immigration Nationality Act, which is the core, set of statutes for immigration law, basically adapted the Refugee Convention's definition of a refugee. So what we ask folks to kind of start that conversation, and we start broadly so we can, gather more information rather than sort of ask in a way where they might give us like a yes or no answer, or in a way that would not allow for more discussion. So these questions are very broad, and then we narrow down from there. But the question I like to ask folks is, have you ever been harmed or targeted in your home country? Or do you fear you might be harmed or targeted if you are forced to return to your home country? And so if someone says yes, then we need to get into why they were harmed or targeted, or why they're afraid. And so the definition here that we have of a refugee, which again is, we use the term refugee and asylum seeker synonymously as it relates to the definition under immigration law, under the Refugee Convention, the only difference being a refugee is outside the United States and being processed internationally, whereas an asylum seeker has already in the US, has already gotten to the US and is seeking sort of refugee status within the United States. So this is an individual who's outside any country of their nationality, or for a person who has no nationality, basically they're stateless, is outside any country where they last habitually resided, and who is unable or unwilling to return, and is unable or unwilling to avail himself or herself to the protection of that country because of persecution or well-founded fear of persecution on account of, and here's the really important piece, is the on account of triggers a nexus analysis, and there are 5 protected grounds for which someone can claim asylum. That's because they're being harmed or targeted or persecuted, or they fear that because of their race, religion, nationality, or membership in a particular social group or political opinion. Now, the membership in a particular social group is like a very lengthy, interesting discussion because on its face, it doesn't, we can't really glean anything from what that exactly means, but it's sort of a category that is left left open for argument so that individuals who are, for example, identify as LGBTQIA, for example, or individuals who are another category that's come up quite a bit under this membership in a particular social group. Um, Nexus is women in countries where, or in communities where they practice female genital mutilation. So those are some areas where we see that membership in a particular social group come up. So again, this is why we ask sort of these broader questions and then start to narrow down so people can explain their stories to us. And then moving on to our non-immigrant status visas. So these are oddly named because of the way that these were created in 2000 for survivors, but there's a U non-immigrant status or U visa and the T non-immigrant status or T visa, which we'll talk about in a moment. So the U visa is for individuals who are survivors of crimes in the United States. And so we ask people, again, very broadly, have you been harmed in any way since arriving in the US? And if so, very important to the U visa specifically, were you able to talk to law enforcement? And this is, again, very broad. But what we're getting at is a requirement under INA 101A15U that define what a what what qualifies an applicant for a U visa. So it's for individuals who are survivors of a statutory list of serious crimes, which are on the form for a U visa. And basically, it's any crime involving harm, and that you must show that you've suffered substantial physical or mental abuse as a result of that certain specified criminal activity. So that can include domestic violence, sexual assault, kidnapping, and attempted murder, for example. Um, you must be helpful in the investigation or prosecution of the crime. And so that's where that second prong of the question, the being able to talk to or connect to law enforcement about this crime is super important because the applicant must obtain a law enforcement certification that basically corroborates that they have been helpful, are willing to be helpful, um, or are in sort of in the process of uh, being helpful in the investigation or prosecution of the crime, whether that's with like a local police department, the FBI, or in the case of like, for example, when family law and domestic violence, a family law judge can sign off on this as well, or the Department of Child and Family Services who relates to child abuse. So there are different law enforcement agencies that an individual can cooperate with, that can sign this certification and say, yes, this person is indeed a victim of one of the qualified crimes, that they've suffered substantial physical or mental abuse, and they have been helpful in the investigation or prosecution. And then one thing to note is that, as I mentioned under family-based petitions, that there are ways that family members can include their family members in an immigration petition. So with the U visa, you can include the principal applicant who is the survivor of a crime, and include their spouse, their children under 21, their parents if the petitioner is under 21, and siblings under 18. So this is where the the survivor is under 21 and their siblings are under 18. So no, that's a little bit weird when we've been talking about 21, we see 18 here specifically. But one thing to note about the U visa is that actually because unfortunately a lot of immigrant community members have been victims of crimes, that there are a lot of applicants, and the U visa has a very generous waiver for grounds of inadmissibility. So the a big one for many people is simply that they enter the country without inspection, so they don't have a lawful entry into the United States. But the U visa, you can ask for a pardon or forgiveness, however a lot of people understand that terminology in the community. But basically, it's a waiver that allows them to say, I have these issues, but because I'm applying for this humanitarian relief, I'm requesting a waiver. So I've had clients who have multiple unlawful entries, even have had some criminal issues, or they've had removal orders and have never left the country, and they've been granted visa status because of how generous that waiver is. The downside is that because there are so many people who've applied and the statutory cap is 10,000 and it's never been raised from 10,000, there are well over 200,000 petitions in the queue, and the wait time for a U visa is now at least 15, if not more than 20 years currently. So that is a huge challenge that we're up against, and it impacts people who are currently being picked up in these ICE raids because some folks have had U visa petitions pending for a long time, and there are arguments that, oh, that well, they can't just stay here while their U visa petition is pending, which was not the case in the past. So we're seeing a lot of challenges with our current, the current backlogs and uh, lack of change in our immigration systems, including something as simple as raising the cap on U visas. Okay, so as I mentioned, there's a similar non-immigrant status known as a T visa as well, and this is specific to the crime of human trafficking. So T visas are only for people who are survivors of a severe form of trafficking in person. And the way that I like to ask individuals, again, to cast a wide net and learn about their situation is, did anyone, excuse me, bring you to the US by force, or were you tricked to come to the US to work? Have you ever been forced to work with little or no pay? And here we see that that in asking individuals that question, what we're trying to get at is whether they meet the definition under the federal code of severe form of trafficking in person, including commercial sex acts or involuntary servitude, peonage, debt bondage, or slavery. So there is again a specific definition, and the analysis that we use when we're uh, making sure that the individual qualifies for under the severe form of trafficking in persons definition, and what we kind of outline in a brief is it is the process means ends analysis. And so we understand that as someone who was recruited, transported, harbored, or obtained, like obtained as a person, um, by force, fraud, or coercion for the purposes of involuntary servitude, peonage, debt bondage, or slavery. And so all of those need to be met to, to for the applicant to be meet the definition as someone who is a survivor of severe form of trafficking in persons. So once we determine that that has happened, we must also prove that that person is in the United States on the account of the trafficking. You know, often if we, for example, meet agricultural laborers, so farm workers who were recruited and then by fraud or coercion are basically in a debt bondage or slavery type situation, and you know they're they're found and they get help. They can, for example, easily show that they're here in the U.S. on the account of the trafficking. And then for individuals who are over 18, this is similar to the U visa, but not as strict. There's an element of complying with law enforcement, reasonable request for assistance in the investigation or prosecution in here under the T visa, specifically of the trafficking. And again, we see that there's a law enforcement agency certification component, but again, it's not as strict. So there are multiple reasons why an individual may not be able to report to a law enforcement agency, including that they're under 18, so that's not even required, or because of serious psychological trauma and fear. And so you can write like an attorney declaration explaining that. I've done that before and had my case granted without issue. And then must show that there would be extreme hardship involving unusual and severe harm upon removal from the United States if they don't succeed in getting a T visa. So that's going to be an individualized sort of assessment. Um, Something that I want to highlight is that the severe form of trafficking in persons and the way that we often read about it in the news, we hear about sort of like larger group cases, for example, the sex trafficking rings and the massage parlors, for example, or like I mentioned, the agricultural workers. Um, there are situations that have that what we call of like crossover. So one that's really important that I want to highlight is domestic violence and human trafficking crossover. So there are individuals who may describe to you what they think is just domestic violence, but really when you parse out what's happened to them, like you know brought to the US and harbored by their trafficker, like forced to stay at home, not allowed to leave the house. Like there's, you know, the domestic violence elements of control and abuse, but they're forced to basically be like servants in the home, caretakers extended family members, and they're held in by force, fraud, coercion, through the abuse. They too can make an argument that they've been trafficked. And again, I've had a case of that approved without issue, where we explained how that abusive relationship was really a severe form of trafficking. And the reason I mention this is because the T visa, while it's similar to the U visa, has a much smaller number of applicants. So the cap for T visas is 5,000, which is half of that of the U visa. But that cap is never met. Like there's never enough applicants. And so for my T visa clients, they've gotten their T visa so much faster, like many years sooner than the U visa clients. And so they're on their pathway to getting a green card and citizenship much sooner. So lastly, I will mention the last humanitarian form of relief is special immigrant juvenile status, also known as SIJS or SIJ. And this is for individuals who are under 21 and unmarried. And we ask, have both of your parents present in your life? So this is only for individuals who are under 21 who are asking this to unmarried and under 21. And another sort of question relatedly is, have either of them harmed or neglected you? So, as Ella mentioned, I used to work in the University of California system. So I came across a lot of individuals who are under 21 and were coming from single parent households or had been raised by other guardians like aunts, uncles, grandparents. And what we found is that they almost always qualified for special immigrant juvenile status, where they could not be reunited with one or both parents because either the absent parent or absent parents were abusive or neglectful or abandoned them. Um, and then the step that where we really got involved was um, getting them a state court order, either in probate court for guardianship, or if they're still under 18, in family law through family court through parentage or in a custody situation, um, declaring them the dependent of the court or legally committed to an individual like a guardian or the single parent, and that the court finds that it's not in the immigrant's best interest to return to their country of origin. So just really want to flag this, that it's a very important form of relief for our youth. And again, I know that this is a lot of information and that I'm trying to condense so much in a pretty short period of time. So I'll, of course, have our email up at the end to ask any follow-up questions and to provide additional resources again. So to round out this conversation on the pathways to legal status, here's a chart for the admission process. So what happens once we identify from those intake questions that an individual might qualify either for a family-based petition or one of the humanitarian forms of relief? Well, they have to submit that underlying petition. So like, for example, these numbers here, like the I-130 is for family-based petitions, I-140 is for employment, or and then the I-360 we use for special immigrant juvenile status or VALO applicants. There's others like the I-918 or I-914 for the UNT non-immigrant visas. Anyway, so we have that as like the basis of why you would qualify for permanent residence. And then the second step is whether you're actually eligible to get the permanent residence or obtain the green card. And so with that, there's either someone is eligible to adjust their status within the United States by submitting Form I-485, or if they did not enter the country lawfully and do not qualify for a waiver, like we mentioned under the U and T non-immigrant visas, then you may have to go to your consulate in your home country and do the DS-260 and consular process, which can present really significant issues, as we'll talk about in just a moment in our last slide with inadmissibility. The adjustment of status is far more advantageous because it's within the United States, it's adjudicated inside the United States, whereas consular processing by its nature is outside of the United States. And I have that little green bubble for the inadmissibility waiver. I will not have time to talk about this long list of important factors that hamper individuals' ability to adjust status, aka get their green card or permanent residence inside the United States. However, one of the handouts that was provided as part of your materials, I think does a really good job of providing an overview of the most common forms of inadmissibility that we see. that impact individuals, and whether they even have the opportunity to ask for a waiver and potentially still move forward with their green card or permanent resident application. So the biggest one we see is unlawful presence. So unlawful presence is any time spent in the United States where you're without lawful status, whether it's after a visa expired or whether it's after entering the United States without lawful documents and you're over the age of 18. Another one that we see commonly is alien smuggling, basically helping other individuals enter the United States, which happens very commonly with parents who, you know, of course, brought their children with them. Failure to appear at a removal hearing or having removal orders. Um, in your past, there's fraud, misrepresentation, false claims to U.S. citizenship, what sometimes people get caught up in when they're taken at the border, and you know, they don't know what to do, but they don't want to be, of course, be in detention. And then there's other serious issues that may be a little more difficult, like political and national security grounds. There's criminal inadmissibility grounds, which is like a whole other, could be a really long time discussions. And then economic grounds, namely like public charge, which we've been hearing about. So I want to try to end us somewhat on time and leave a moment or two for questions if there's been any questions in the Q&A, which I haven't had a chance to look at. And also note where we can find additional resources. So as I mentioned, I highly recommend if you have a moment, please read that handout. That's part of your material, The Grounds of Inadmissibility for Permanent Residents by our friends at Citizen Path. It's a really great set of online resources on their website. But this one I thought was my favorite. It's been my favorite handout in terms of explaining inadmissibility. And it is kind of client facing, so it's really easy to understand for folks who are not in the day-to-day practice of immigration. And then a rescreening for relief handout, which basically goes over everything that I discussed plus a little more. And it's very timely. It's put out by the Catholic Legal Immigration Network Clinic at the start of the year because so many folks who have temporary protected status, for example, or other temporary forms of protection have had that stripped and are in a limbo situation since the start of the new administration. And so something that folks are, you know, scrambling to figure out is whether they have other options available to them. And so this rescreening for relief is a great guide because it basically provides a rubric for consultations. In general, but it is a little tailored to the individuals who are you know, very affected by the new administration's rollback of protection. And lastly, as I mentioned, there's a number of follow-up videos that you can watch for each of the forms of relief that I mentioned and the ones that I didn't get to under employment-based. So under the Pro Bono Training Institute, PBTI, which, you know, shout out to my previous organization, One Justice, that provides this platform and hosts all these great videos. I send this video series to our volunteers so that they can watch on their own time and go into as much detail as they'd like. There's an Immigration 101 series that basically covers what I just covered, but in a little more depth because there's more time in the videos. And then there's like a series on adjustment of status, for example, a series on asylum, U visa, etc. I highly recommend it as a follow-up. And then lastly, if you have any questions or are inspired to volunteer with us at Counsel for Justice, please contact me at volunteer@counselforjustice.org. That is routed to my inbox, so I will see these emails. And also, as I mentioned at the beginning, we're celebrating our 50th anniversary of our Immigration Legal Assistance Project. And so stay tuned. We'll be sending the HBA a follow-up on our save the date for our September 10th uh, event for our celebration of our immigration work at Counsel for Justice. So again, thank you very much for your time, and I'll stay on for a few moments for questions here.
Okay, so it looks like we have a few questions. One of them from a Sherry Diamond asks, given the years and decades long backlog, what happens when an individual ages out of their respective category?
Great question, Sherry. So I didn't even get to age out or the Child Status Protection Act. So depending on the type of relief that is applied for, there might be protections from age out. For example, immediate relative petition, your age is frozen as of the date that you apply. So like I had a student who was turning 21. I still remember this on November 17th, and we uh, begged USCIS to schedule the mom's naturalization interview on November 14th. And as soon as she completed the naturalization interview and took the oath, um, we submitted the petition like the next day, and her age was frozen as under 21 for that purpose. Not all categories benefit from that, and so it is a specific case by case specific inquiry about the type of petition and where that individual fits in, like as a derivative or principal, etc.
Okay, and then I have another question from a Mr. Jack Russo. He's mentioning a hypothetical.
Mhm.
A startup founder who just graduated with an MBA at Stanford, but no money, asks for help. What is possible?
Yeah, that I will gladly admit is out of my wheelhouse in the sort of legal aid world. There are amazing attorneys in Los Angeles, and if they're still in the Stanford area, Bay Area, in the private bar who work on employment-based options for individuals who have professional degrees or might even qualify in their like an entrepreneur category. And so I highly recommend reaching out to one of our colleagues who does those type of cases, and I'm happy to provide referrals if you'd like to email us.
Great, thank you. And then I do have someone asking about I trying to see if you can rephrase or a question regarding the due process rights for undocumented individuals. Oh, oh, let's see.
I guess I'll just make a plug to for Know Your Rights or KYR presentations. And while those may not cover every issue area, and there's kind of different forms of Know Your Rights, and we used to do them in the federal building where our clinic is housed for individuals who are going to have immigration court hearings and ICE check-ins. There's a lot of wonderful Know Your Rights resources out there about the rights of our immigrant community members who are, subject to being at risk for detention or deportation proceedings. And so it is a very difficult time as folks know out there, and there's been a lot of violations and challenges. And so, again, happy to share kind of like current events and resources if you are looking for something specific and want to email me.
Alrighty, great, thanks. So that's just about it for questions. This concludes today's presentation. We would once again like to thank our speaker, Habiba Simjee, for such an excellent presentation. And of course, a big thank you to our audience and our members for learning with us today. Have a great day, everybody.